Thank you. We are on the record. Thank you. Today is Monday, December the 10th. This is the Tennessee State Board of Cosmetology and Barber Examiners, and we will start with the complaint committee meeting. It is 9:30 a.m. Today we have with us Ron Gillihan, Ms. Becky Russell, and Amy Tanksley, and Mr. Frank Gambusa was not able to join us. I will go ahead and turn it over to our attorney, Ms. Pam Spicer.
Good morning, everyone.
Hello,
Morning.
Pam.
There are a few cases we definitely need to discuss this morning, and you all may have questions as well. I want to turn your attention first to number 47 and 48.
You're on page 15?
Yes.
Okay.
These are represents. These cases have been pending since 2015. As you can see from the summary, this involves a procurement of a fraudulent license. The respondent on 47 is the owner, and 48 is the shop. These cases were set to be heard this month. However, opposing counsel filed a motion to continue and a motion to request mediation. While mediation is not required, it is provided for in the rules, and opposing counsel requested it. At that time, the administrative law judge asked that I speak to my client, that being the board, to see if you all would entertain mediation. Legal's recommendation is that we do entertain mediation, given the history of this case, particularly the length of time that it has been pending. It may be beneficial for all parties to mediate. Of course, as this board knows, normally I come before the board to obtain approval, whether that be for revocation, civil penalty, whatever the recommendation might be. You all approve that. When we go to mediation, that's going to be difficult to do, so I'm asking that you give the executive director authority to go to the mediation with me, and the case could be settled at that time. Obviously, for purposes of today's meeting, we can't discuss what might happen in the negotiations. So you would be giving the executive director authority to settle the case, which may be by civil penalty or may be by revocation, but it may not be revocation. We won't know until we get to the mediation. Just so you all are aware, what happens is in the past, all of the cases have always been heard by an administrative law judge. So in this instance, when I submit the order that we're in agreement to mediate, there will be an administrative law judge assigned to mediate the case. And then if for some reason the case does not settle, a separate administrative law judge will hear the case if it goes to a hearing. So that's where we are, and that's what I'm asking the board to give legal approval to do.
I don't see any objection to having Roxana be able to settle this case. She's pretty familiar with the will of the board.
Yes.
So we need a motion for you.
Yes, for those two, we'll need a motion that you're accepting the recommendation of legal and giving executive director approval to mediate this matter and settle it at mediation.
Make a motion that we accept the recommendation of counsel and that we allow the executive director to represent us during the mediation.
Second. Good second.
Yes.
So we have a motion and a second. All in favor say aye.
Aye.
Aye. Motion carries.
Thank you. The next complaints that we need to discuss, also, they start on page 16. They would be numbers 49 through 57.
This was a school, correct?
Correct.
Okay.
I do want to say first, I did not handle this matter. This matter was previously handled by Robin Ryan, attorney with our office. She executed a settlement by agreed order. There were very specific items contained in the agreed order that the school needed to comply with. The school has not, our position is the school has not complied. Since I have been involved in this matter, we have requested that we be allowed to inspect certain records. We even went so far as to schedule an appointment, which we did not need to do, and the school has still not complied. Based on that and based on the terms of the agreed order, the matter was never litigated. So now we're to a point of needing to refile the notice of hearing and charges and have this matter litigated. And then here's where this is going to be a different situation, because legal is asking that the board hear this matter and not an administrative law judge. It's my understanding you all have not heard a matter before.
Not since I've been here.
Okay. So how this would be different is that there will be an administrative law judge present. That judge rules on the procedural matters, like if there's an objection to whether something's relevant or not. The judge would decide that. But you all would ultimately be making the decision on whether, if legal recommends revocation of the school license, you all would be determining that, and it could be anything from a civil penalty to revocation.
Is our legal counsel involved in that process? Right.
So I would be presenting the case, and you all would be deciding the facts. Sort of, I guess, like a jury, basically, would be the best way to describe it. The administrative law judge would sit like the judge, making procedural decisions, but you all would be deciding the facts as I present them. And of course, the school would likely have an attorney present representing the school's interest. We would go back and forth just like you would see in a normal court of law, meaning I would present my opening statement, they would have an opening statement, we would present our witnesses, they may have witnesses. Ultimately, you all would be deciding on the facts.
Would we be allowed to question the witnesses or ask questions, or is this just a presentation?
No, you would be, this would be the actual hearing, and
Okay.
you would be allowed
So we
to
can ask questions. All right.
The recommendation of legal is for, first, that legal deems that the respondent is not in compliance. So we are requesting that legal be allowed to not relitigate, but litigate this matter, which would require us to file a new notice of hearing and charges, and that in lieu of an administrative law judge only hearing this matter, that the board hear this matter because of the board's specific knowledge related to schools and how they are supposed to operate.
In the event of a non-unanimous decision, is there a balance that would uphold or deny our claim? So if we say yes, we want to take this action and revoke a license or have a civil penalty, does it take a majority of the board, or is it a unanimous?
As far as I know, it's a majority.
Okay.
I don't want to I don't want to misspeak, but as far as I know, it's a majority. Of course, the matter can always be appealed
Sure.
by either party if for some reason whatever you all decided, the same appellate procedure would be in place if they wanted to appeal.
Tell me those case numbers again. It was 40.
It starts number 49, 50, 51, 52, 53, 54, 55, 56, and 57.
School still open for business?
Yes.
They are. With students. Okay. Thank you.
It looks like we don't have any information on 54. Is that correct?
.54 and 55 are combined. It's not that there is no information on 54 and 55. The summary that's below 55 attaches to 54 and 55. And those are as they were presented at the time. That's why you see, above number 49, it says November 2014 cases, because we're trying to give you all a timeline of how this has come to be.
And you need a motion from us now, or?
Yes, I think because we're separating these out, and it's somewhat of an unusual circumstance, that we should have a motion on that, on these particular.
Sure. And the motion is that we are taking your advice to have the hearing with the board and the judge.
Yes, the motion would be that the recommendation of legal to refile and litigate this matter, and because of the issues and concerns, that the matter be heard before the board.
All right. I will make a motion that we follow your advice and we move to litigate and refile and then hear the case as the board.
I'll second that.
We have a motion and a second. All in favor say aye.
Aye.
Aye. So motion carries.
Thank you. And then I just want to point out 58. That actually is my error. The notice of violation, the way it was worded, I believe I misread it. So I wanted to come back before the board and institute and recommend a new civil penalty. Originally, I had only recommended 200, and it should be 600.
That was one of the questions I had earlier. So, okay.
600.
Yes. I do not have any other complaints to specifically point out, but I'll be glad to answer any questions that you all have on any other complaints.
And have any others? I assumed we would speak about the cases at the end.
I had a question about 8, 9, and 11. They look like very similar or similar complaints. Are those all for the same shop?
On 8,
8, 9, and 11 look
8 and
similar.
9 are related. The 9 is the shop. Number 11 is not related. Different shop on number 11.
On number 17, licensed activity on a Facebook page. Can you tell me a little bit more about that one?
I can go back and look during the break, but the information we have is this is probably the extent of it, meaning I'll speak more in general terms. There are times that we get complaints filed stating that people are providing services on Facebook, but it's very difficult to prove, be legal's position, particularly if the respondent provides a response. Then she's also stating, or this individual is stating, that she doesn't charge for her services. So she did provide a response. Sometimes we don't get a response, but that's pretty much the extent of it. I can go back and look at the complaint, but it probably is fairly limited in nature, meaning we get a complaint in that someone's providing services on Facebook. Sometimes the respondent will respond, sometimes not. And depending on whether we can substantiate it or not, we have to make a decision whether we think we could go forward with litigation.
On this one, since she stated that she does provide the services but doesn't charge them, she's admitting that she does do it. Or a cease and desist on that.
We can send her a letter. Of course, one of the issues is she's stating she doesn't charge for the services.
That's
but
not a factor, though.
We can send her a letter indicating, I don't know that I would call it a cease and desist,
Right.
more of a letter of warning, just making sure she understands what she needs a license for. We can't really give her legal advice, but we can send her a letter of warning, which will at least cause it to be flagged, correct, in case another complaint is filed. Also, we will attempt to do that, but I have to have an address, which
Right.
I may not have, which is also part of the ongoing problem with someone that provides a complaint alleging a Facebook incident. I have to be able to locate the person, but we'll do our best to come up with an address and send her a letter of warning. And I'll change that recommendation to letter of warning.
On number 34, that appears to involve some apprentice students working in an unlicensed shop. If there's if the students are under an apprenticeship program, then that indicates that some school is overseeing that. So maybe we ought to take a look at what school they're involved with.
And on 34, I did recommend a request for inspection because we really didn't have enough information. And I think if we go out and inspect, we can make all of those determinations through the inspection process. Then, of course, if there's any violations noted, we would simply open a new complaint and have more information from the inspector.
The inspector also checked to see that those folks are able to have an apprentice student, such as having their license for 10 years, all of those things. Will it just be making sure that the shop is licensed?
No, we can ask the inspector to go to do more than just inspect the shop, especially because they're inspecting based on the allegations that are in this complaint. So it's not just a routine inspection. Anytime we're asking them, anytime when legal recommends a complaint be inspected, they have all of the information contained in the complaint. So it's not just a routine inspection that they might be doing annually or whatever.
So they look at the records potentially and the office records, things like that.
They can ask.
Prefer that they do that since it's involving students. I want them protected as much as possible.
And if I could add, I think this is our first one where we'll have to follow through all the way to the school for the apprenticeship. So I think once we have that inspection, I would be comfortable. They may all be with the same school, or not. But that's what I'd like, is to make sure that the school, because the shop's going to have very little paperwork, right? The shop's just responsible for the 10 years of license and a one-on-one and that kind of thing. But then we're going to follow up with the school to make sure that they've got the right person assigned to each student and so forth.
A lot of misunderstanding about how that works.
Yeah.
Right now, we don't know which school. We don't have any of that information.
Talked about 47, so that's the only ones that I had. else?
Well, we make a motion to approve then with the comments that were made and the additional motions that were passed. Make a motion to approve the legal report.
Motion and a second to approve the legal report. All in favor say aye.
Aye.
Aye. Motion carries.
Thank you.
And if I could, Miss Patricia? I think she's still with us.
Yes, I'm here.
Thank-
I'm here.
Thank you. I had her join us to make sure we had quorum for today's meeting, just because with the weather and everything, we weren't sure who would be here. I appreciate you being with us. Thank you so much. And so this concludes our legal committee. We'll start back at 10 o'clock. Thank you.
I'll call back. Okay.
Thank you.
Bye bye.
Bye-bye. Thank you. We're on the record.
This meeting of the State Board of Cosmetology and Barber Examiners is called to order. We will begin by doing a roll call.
Thank you and good morning. Today is Monday, December the 10th. We are starting right at 10 o'clock, and we've got several people participating electronically, so I'll do roll and then we will know which have joined us so far. Ms. Kelly Barger?
Here.
Thank you. Ms. Anita Charlton is not with us. Ms. Nina Coppinger?
Present.
Mr. Frank Gambusa is not with us today. Mr. Ron Gillahan?
Here.
Ms. Wyvette Granger?
Present.
Thank you. Ms. Brenda Graham is not with us today. Ms. Judy McAllister?
Present.
Ms. Janie Ross?
Here.
Ms. Patricia Richmond?
Present.
Thank you. Ms. Becky Russell?
Here.
Ms. Mona Sappenfield?
Here.
Ms. Amy Tansley?
Here.
Thank you. And that's our full board, and we do have quorum.
Thank you very much. One of the first things we like to do.
Could I interrupt you? I'm
Sure.
so sorry. Sherelle Hooper, our attorney, is going to need to read the statement of necessities, and several people
Oh,
are
absolutely,
participating
yes.
electronically.
Good morning. According to Tennessee Code Annotated 8-44-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it is based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, Tennessee Code Annotated 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting requiring timely action by the body, that the physical presence by a quorum of the members is not practicable within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is a regularly scheduled meeting for the Tennessee Board of Cosmetology and Barber Examiners, and the purpose of today's meeting, with some members attending by teleconference, is to discuss the agenda as noticed on the website earlier. As we noted with the roll call, there are 4 members attending by phone, and this is how we are meeting our quorum today. Thank you.
Okay. Thank you, Cheryl. I was about to say we like to take a moment and recognize our visitors and guests who've come down to participate in the meeting. Thank you all for coming and being here. As I look at my agenda here, it appears we've got several schools here today. When I call your school name, if you would, just stand up and be recognized for just a moment. So, is there anyone from Naturally Yours Hair Academy? Thank you, ma'am. Thank you for being here. American College of Barbering. Welcome. Larry's Cosmetology, Massage, and Barber School. Hi there. Austin's Beauty College. Good to see you again. Paul Mitchell School. Welcome. And Global Beauty and Barber. Okay. All right. Thank you again, folks, for being here and participating in your board meeting. The next item of business would be the approval of the November 5th, 2018 minutes. Are there any additions or corrections or deletions? Hearing none, do we have a motion to approve?
Tricia Parsons, I make a motion to approve the minutes.
Second.
We have a motion and a second to approve the November 5th, 2018 minutes. All in favor say aye.
Aye.
Aye. Aye.
Both say no. Motion carries. Okay. Ms. Roxana, it's in your court.
Thank you. We will start with our first school. On your iPads, you have the presentation for Naturally Yours Hair Academy. I will ask Ms. Delaney to come up if you give me a minute. Thank you, members. This presentation and application was presented to the board at the November meeting. Ms. Latasha Delaney is was asked to clarify and make some changes to her contracts as well as the floor plan. You have before you a new location to the school, and so that is a new floor plan, including a couple of images of the space itself. So she has rented something that is bigger. The school is located in Memphis and is 900 square feet. The business license, curriculum, blank contract, 5 tentative contracts, new floor plan, application fee have all been received, and I will let you review and ask any questions as needed.
Roxana, what is the address of the school? This is Bona.
Hi, Mona. Absolutely. Give me just a minute, and I'll read it to you from the application. That address is 6847 Guilford Drive in Shelby County.
Okay, thank you.
And actually, that's their mailing address. Let me correct myself. The business address for the unit itself is 3845 Viscount Avenue, Suite 308. Is that correct?
That's the old address. When I sent you the new one, it's 3835.
The application hasn't been revised. I'll make sure that she completes a new application. Hold on. 3835. Her enrollment agreement has the new address, 3835 Viscount Avenue, Suite 9. Is that accurate?
Okay. Is that a school that I have inspected that was new, like maybe 2 years ago? Or
I don't believe so, ma'am. This is a school
It used to be a salon previously.
This is an apprenticeship school. It doesn't have square footage or the equipment for services to the public, and
Okay.
so it used to be a salon, is what she's saying, but it was never a school.
Okay.
Is that correct?
Thank you.
Mhm.
Thank you.
You're welcome. Thank you.
So walk me through it. How many hours are done in the school then? 100?
No, it would be 50% at the school.
Right. So total hours for natural hair is 300. So they would do 150, half of it with me and half in the salon and barber.
How many square feet did you increase by changing your space?
Well, the previous square footage was, I think it was 180 for that area. So I was real concerned about it because it really was just a suite. But I moved into an actual building where it's more square footage. It has 3 different rooms. Where the biggest room, that's where the classroom will be held in the very back of that floor plan that you see. So I have, room enough where we could do, have a break room, then they have a restroom facility inside the building. So I have a actual building where
Is there
everything
a
will be
restroom in
inside.
this space or?
Yes, it's restroom inside the space.
Okay. Cool. Are there any other questions?
Page 14, the address is 3845 instead of the 3835. Should that be changed?
I don't think we have consistently the correct address. I'll need her to fill out something that gives us just
Yes,
one
it
in one
says the
place.
application, or because I not corrected it on the enrollment contract.
Actually, on your enrollment agreement, on the first page of your enrollment agreement, it's 3835,
Yes,
and then
because I know the last
3845.
meeting, the concern was the contract and the floor plan. So I know that's what Roxanne was concerned to make corrections of that. So I'm gonna make corrections of the other.
The contract itself has under the location, under number 2, understanding as the catalog location is still listed with the wrong address.
It is okay. I'm gonna go back over it.
Are there any other questions on this one? We need some more time. Do we have a motion?
Make a motion that we approve the application for the new school.
Second.
I second it.
Amend that to adding the address changes, the corrections.
Yes.
Thank you. We have a motion and a second to approve with those address changes. All in favor say aye.
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 Opposed say no. Motion carries.
If I could add, just to make sure, because we had some concerns with the smaller space and she's had to come back, normally we always send the field inspector, so this will not apply until the field inspector turns that in. Would the board like a board member to go as well, just because it's come back once, or are you just comfortable with the field inspector?
I think we can send a board member just to make sure everything works out.
Okay. Agree. Sounds good. Thank you very much. As soon as I've got everything updated and the address is correct in all of our documents, I'll coordinate that inspection.
Congratulations and thank you.
Congratulations.
Thank you.
Congratulations.
Thank you. Next, you have American College of Barbering. This is a new barber school, and if you give me a minute, I'll have Mr. Thomas James prepare.
Thank you.
Morning, Thomas.
Good morning, Mr. Ron.
You have before you an application for a new barber school. This school is located in Murfreesboro and is a total of 4,850 square feet. The business license, curriculum, contingency plan, the 15 contracts were received today. You have the floor plan before you, application and fees. I will let everyone review and ask Mr. James any questions you need.
First School, Thomas. I like all the detail you have. It looks great. Your layout looks fancy. I like it.
I had a question about graduation requirements. It says final test must pass final test before taking the Kentucky State Board exam.
That's a misprint. My apologies. It should say Tennessee. I'll be sure to change that up and resubmit. My apologies.
Well, I didn't know if they were getting licensed there as well.
No, ma'am. I'm sorry.
Thomas, I've seen some of the pictures you posted. It's a beautiful
Thank you.
location. You've done a lot of hard work in there.
Thank you. I'm trying.
In your drawing, in your layout,
Yes, sir.
you obviously have plenty of space, but I don't think I see any definition of where your stations are going to be and things like that.
I would need to see the graphic, but the picture that you guys have, the easiest description I can give, the floor plan that you guys have, in the middle of it, there's like a semicircle. Okay, that's where the 5 shampoo bowls are. If you, from either of those exits going away, hold on just a second. Thanks, Ms. Warren. The 2 large rectangles on the right-hand side of that graphic, there will be stations right in the middle of those. I have it set up. There's a pole in the middle, and then, there are several poles in the middle there with mirrors, so the stations are on each side of those. And I have pictures in my phone as well if you guys would like to see those also.
Since it wasn't in the diagram,
Can we approve this and ask for an updated floor plan?
We can, yes, that's not a problem. And we will need an update to where Kentucky is removed, so I'm glad you noticed that.
since I didn't see it listed on there, I just wanted to kind of identify that a little bit.
Like to see an actual photo of that now? Okay.
I believe in the past we've just approved it showing exactly where the stations are going to be, and that can be fixed easily.
Are there any other questions? Do we have a motion?
I'll make a motion that we approve pending an updated floor plan and the removal of the Kentucky licensing with a board member inspection.
Second.
We have a second.
Second.
All in favor say aye.
Aye.
Aye. Aye. Aye.
Opposed say no.
Aye.
Motion carries. Congratulations and
Thank
good
you,
luck.
sir.
It's a beautiful place.
Okay. Next, you have, starting on your iPads on page 28, this is Larry's Cosmetology, Massage, and Barber School, also a new school. If you give me just a minute, I will ask Mr. Roberts to step up.
Okay.
Mr. Larry Roberts Jr. is appearing before the board to answer any questions you have. This school is located in Memphis. The location of the school is for a school that previously closed in September of 2018. This school is going to be located at one of those two locations. They are applying for two separate licenses, a barber school license and a cosmetology. Is that correct? Yes. And a cosmetology school license. The business plan, curriculum, contingency plan, contracts for the barber part, floor plan, and everything have been received in the board office. I will let you review everything. Obviously, the floor plan is just one, but you'll see on your iPads on page 29 and 30 are the two different applications because they are separate licenses.
Welcome.
Good morning.
What is your total square footage on your building?
1,700 square feet.
So, it's 17 for each or 17 for both? It's a grand total of 1,700 square feet?
Oh, I'm sorry. 7,800.
Oh, so thank
78.
You.
Oh,
Yes.
thank you. Wow.
I'm sorry.
You saw
Big difference.
faces.
I'm sorry.
You're fine.
So can I ask a question about the massage? Is that something you're offering, or is that just the name?
Well, it's going to be, it's going to be another entity of it. But of course, you guys know it's a different application that goes along with that.
Right. Okay.
Yeah.
Thank you.
You're welcome.
And Roxana, remind me how that works when you've got multiple disciplines in the same school. Some of the space can be shared, some of it can't be.
Right. So in the past, we've even let the floor plan be flexible depending on the layout. Sometimes the layout presents itself to where schools have chosen to split it completely. He has the space to where he may be able to do that. They cannot share classrooms unless you have, one cosmetology all day and the evening classes are barbering. So the classrooms would have to be unique and not shared. But other than that, the entrance is shared, obviously, restrooms, break rooms, the floor space. Just what we've said in the past is for barbering and cosmetology, the chairs are different so that you'd have to have some type of identification so that you're taking clients to the proper area depending on the service being offered. You're welcome.
So there's no problem with the two
Be close to each other or
Yeah.
together. We have not seen one in the past. As long as the school is duly licensed, classes are being taught by the correct instructor,
Right.
barber instructor versus cosmetology and so forth.
It looks like one of your instructors is a licensed barber instructor and cosmetology instructor.
Yes.
Did you say it was closed before?
Yes, this is one of the two Tennessee Academy of Cosmetology that closed in September. They closed two of their campuses, so he is reopening in one of those locations on State Road.
Now, were you a part of that previous school?
No, I wasn't. I'm actually from another state, but I have 7 other schools.
Tuition, correct?
Yes, it is.
You have how many other schools?
7.
Are they in different states, I guess?
I have a couple in other places, but I have 3 that's in Chicago. I have one that's in Peoria, Illinois. I have one, first and only, inside of Cook County Jail in Chicago, Illinois. I have one in Dallas, Texas as well.
So if I could add a quick question on the page on your iPads, board members, this is on page 32 for the contract under cost, method, and payment. A couple of things. I guess we asked about the tuition because you're listing it as 0.
Oh no, that's just an example.
Okay.
That's just an example for the.
So there will be a cost for the tuition.
I'm sorry.
That's okay. That's why the confusion.
I didn't want to argue with you, but I thought, well, right.
No.
Good for you, man.
No, tuition be 14,000, probably 230, because I have Title IV as well.
Okay.
But of course, you don't have to get this school accredited, then get the Title IV for this school.
Okay.
I'm sorry. It's just an example that my staff just put on there.
So I got a few people who might be interested in your school.
Very interested. And
Well, I do have a non-for-profit, and with my non-for-profit, so I'm at 2 state juvenile detention centers as well, but I'm in Cook County Jail. I've been there for 9 years, but I do it for free. So their tuition is $14,000, but it's zero. But I do have another corporation, which is my non-for-profit. So through my non-for-profit, and I have a day reporting center as well. So I kind of make them work together just to kind of help cut down on recidivism and also give an alternative to violence.
Cool.
Yep.
On the last question I think that I have, on the same breakdown of the programs, you've got massage 700. Is that your plan with the medical board and the full massage, or are you talking about within our program?
However we need to make it work within the program, we'll make sure that it lines up to that. But of course, with any, whether it's natural hair, nails, massage, or whatever, in order for us to qualify for Title IV, it has to be 600 hours or more. So we can add it on however the board asks us to.
The discipline within cosmetology in Tennessee is called aesthetics, not actually massage. It would include beautification and facial massages. And then you'd list that at 750 if you're going to offer aesthetics.
Okay, gotcha. All right, so 750. Okay.
Yeah, and you mentioned, I think you and I had talked about that. If you're offering actual body massage, that's through the medical board, and that would be completely separate.
Right, and I talked to
yes, I knew you had. Thank you.
Roxanne, it's Mona. So is the school going to offer aesthetics as well?
His plan is yes. So his contract, and I apologize to the members calling in because these are all applications that would need redaction. You're not looking at the full documents. He has cosmetology at 1,500, barber 1,500, massage, which he's going to revise this to say aesthetics because in Tennessee it includes the whole thing. He's planning on offering it, and it would be the 750. And then he's also offering the educator training program, which is 300.
I believe we've got some discrepancies in the instructor hours. You have 500-hour program and a 1,000-hour program, and that exceeds the requirements. It's on page 33.
Under length of course needs to be consistent.
At the bottom. Mm-hmm. At the bottom under your length of courses, they're not listed at the correct numbers.
Okay.
Will he be offering the duo of the apprenticeship program as well? No.
Hold on, Mona.
Definitely. You're seeing it 'cause you've got it.
Okay. So, if I'm not mistaken, correct me if I'm wrong, I believe it's the same where if you've had your license for more than 3 years, you only have to do 500 hours for your instructor's program. But if you had your license for under 3 years, it's 1,000 hours. So is that
not in Tennessee? No.
Okay. So
all the same, correct?
It's all the same.
Okay.
Yeah, it's 300. And if you are a licensed instructor in one of the disciplines, you wouldn't redo school in the other one. Because it's all teaching methodology.
Okay, got you.
Yeah.
So it's 300 for both.
Correct.
Okay. All right. So that's a mistake. So that's a mistake. Sorry about that.
But you have to have 3 years, right? Before you can.
You must be licensed in that discipline before you can get your license as an instructor.
For 3 years. Yeah.
Okay. So that's where the difference is. Okay. Got it.
We've got a similar issue on page 42. You're requiring 1,000 hours for the Cosmo instructor, so there's several places in there.
Yes, sir. I'll change that.
That would cause you to have to shuffle all of your hours under your theory and practical schedules as well, because you have those broken down into how many hours per each portion.
Okay.
Approve the Barber and Cosmo programs and hold off on the instructor program until that's corrected in the application.
I think the entire contract will have to be revised, and we can definitely hold off on sending a board member and a field inspector until it has been corrected. And I may end up, if in doubt, and because there's just a lot of corrections, send it to a couple of board members just to independently make sure I didn't miss anything. But I think we can treat that separate if the board's comfortable with it, with the approval of the inspections, as long as the full contract is reviewed and corrected, because the aesthetics will have to be named as that, since at least under our program, it's not massage. And then the number of hours, the instructor piece is throughout, yes.
Because the detail's great.
Mm-hmm.
You've just got a lot of hours.
Okay.
There's one other concern when I'm looking at the layout drawing here, and I realize you have quite a bit of square footage, but just like in the previous school, we don't have any actual layout of where your chairs, where your practical stations are going to be, and I don't see anything in here that's specifically set aside for the massage area. So if we're counting these spaces together, we need to really know where all that stuff is going to be.
Thought I put it on there, but maybe not. So
For the cosmetology curriculum, I would like you to look at that and the law very carefully. I think that we've got some hours that are a little off as far as the physical, chemical, and general hours. So just making sure that those line up specifically with the law. I do think those need to be moved around maybe just a little bit.
Roxanna, I know this may slow things down just a little bit, and I apologize if it does, but I'd be a little more comfortable if we just had this really kind of cleaned up and brought back. I'd really like to see how that layout's going to be, particularly since we're going to be, utilizing that as deal space and things like that. I don't know how everybody else feels about it.
Ron, I'd be happy. This is Mona. I'd be happy to look at the aesthetic part of it, since it's a little confusing with the massage. If you could send it to me electronically.
Yes, Miss Patricia Parsons, and I think that I would be more comfortable if he resubmitted next month and got everything in order, and that way we would have a clear understanding. He would understand our laws better, too, of what we require in the state of Tennessee. So I'd make a motion for him to clean up his little thoughts.
May I say something?
Come back.
Sure.
So I think it's a matter of my staff probably just made a mistake in the language in the enrollment agreement as far as the hours and stuff like that is concerned, because it's kind of like it's similar for other states. I mean, Texas is different, but as far as understanding, what needs to be understood as it relates to the laws and stuff like that, that's really not an issue. It's just really a mistake in the language that was used inside the paperwork, which, I mean, I could literally get that cleared up like as soon as I leave here, so it's not an issue at all. And the reason that you probably, I believe that I put the massage area on there, but the reason you probably didn't see it because of the fact that since it has to be done through a different board, I thought that I couldn't recognize the massage aspect on there.
So the aesthetics, will you have a separate room?
Yes.
Okay, where would that be?
So I'm trying to look where this is. Yeah, I just didn't name it that. Yeah, practical room is classroom. And then also, Sorry. So these these two rooms are used for aesthetics. One even has a shower in it, and then this bigger practical room slash classroom also is used for it will be used for aesthetics as well. So there's three rooms for aesthetics.
Roxana, on page 49, it says admission requirements. Should he put under barber instructor that you have to have a barber's license for 3 years? That's something kind of new for Tennessee.
Oh, okay.
Yes, I would for both instructors that in order to obtain a license as an instructor, you must be licensed in that discipline for 3 continuous years. At this point, that continuous still needs to actually be there.
Okay.
Yeah, that's kind of new. So if they enrolled in that, if they had only had their license for a year and then they enrolled in the instructor class, they wouldn't be able to get their instructor license. So they'd have to retest later and all that stuff.
Okay,
So.
I understand. Okay.
Folks, we do have a motion on the floor to have him represent. We'll need to deal with that motion. Do we have a second?
I'll second it.
Who was that?
Who is this?
Yvette Granger.
Ms. Granger? Okay.
When is our next meeting? January
29th. It's
Oh,
that
it's in the
last
month?
Monday.
Okay. We have a motion and a second to have him represent in January. Is there any other discussion or questions?
I just want to, if we're going to postpone him, I just think that we need to make it real clear about what he needs to clean up.
If I can interrupt for a minute, if I could ask that, thank you. Someone that's participating electronically, if needs to mute us, if you could. We've got a lot of echoing. Thank you so much. All right.
This is what I'm talking about.
Ms. Coppinger, you had either a question or a point.
I just, he obviously owns a lot of schools and has been in this business for a long time. And if we're going to postpone him, I just think we need to make it very clear about our expectations of what he needs to come back with. Because, we just approved one a minute ago with some corrections coming through. So, a lot of it is great. And I just... I don't know. I just see both sides that, it'd be easier on us if you just come back but that's not really what you came here for.
I drove 3 hours.
Yeah. So I just think it needs to be made clear to you exactly what needs to be changed. And if that's a whole lot of stuff that needs to be changed and that's making us a little uneasy.
If I could say for me, and realistically, I could literally go out in the hallway and have it changed right now. So, it's literally, it's that easy for me. So my point being is that, if you could approve it and trust that I can get the information back, then, that would be great, for me to have to wait until January. If I have to do it, I have no other choice, but this is not something that would take, it's an easy fix. I think it's just a miscommunication in the, the information as far as the hours and the structure of the hours and all that kind of stuff. So.
But honestly, with the meeting being January 29th, that's a lot longer out than I was anticipating for that.
28th, I wanted to make sure to give, yes.
Okay. I think you see our concerns. There's if it was one address or a simple thing that's that pretty easy to fix, one little item, 2 small items possibly. But with the differences in the hours and things that have to be corrected on your programs and such, there's quite a bit of stuff in there. I'd love to give you an opportunity to make those changes, and if they can get submitted to Roxana, to be reviewed, to make sure they're all done, that would be great. We do have a motion on the floor with a second. So we're going to have to vote on that motion. And if it
This is
passes,
Kelsey Vargas. Is it a possibility to table this motion just until an hour or the end of the meeting and then give him a chance to represent?
I would think that that would be a good idea because there'll be other business taken care of over the next couple of hours. Maybe table it and reopen it as new business at the end of the meeting or something.
Okay.
This is Mona.
And this is
Okay, one at a time.
Granger. I do think that that's a great idea.
Okay. Do you think you could get some of these things back to us pretty quickly?
I can get all of it back to you.
Okay.
If I may, if you can just have somebody or Roxanne or somebody just tell me exactly what you want me to do, and I can have it done right away.
Well, I guess my question is to the board. Clearly, there are some major issues with your instructor courses because the hours it doesn't follow our laws here in Tennessee. That's the biggest concern that I have because those are really wrong. And clearly there's a lot of work to go into just clearing up that section. I'm okay with approving, and I ask for the school folks, the Barber program and the Cosmetology program hours are correct, that I would feel comfortable approving that portion of your school with an updated floor plan and ask for the instructor piece to follow in January, since that's the part that needs the most work.
Yeah, that's fine. That's perfect. Because, I mean, you can't do instructor right away anyway, you know what I'm saying? So that'll be perfect.
I would tend to say, because I'm not looking at the aesthetics piece, and currently it's called massage, maybe postpone that to the next meeting as far as approval one way or the other.
The aesthetics then as well?
Yeah, the aesthetics is referenced as massage at 700 hours. I don't see anything major besides that. That school, remember, he's going into a building that taught. They were not duly licensed, so they didn't have the barbering piece. He's bringing that in for the first time. But that school had a large aesthetics program, without a doubt.
It really can't be it's not totally approved until an inspector
Right.
and a board member goes in. And the board member is going to look at the paperwork,
Yes.
correct?
Yes.
Okay.
Yes.
All right. Well, in that case, we've had a recommendation about tabling this based on Amy's suggestion to approve the Barber and Cosmetology. If we had our members withdraw their motion in second, we could proceed with a motion to approve just those two programs.
This is Yvette Granger, and I do withdraw my second.
Trish Parsons, I withdraw from the table.
How's that?
Thank you.
Do we have a new motion?
Sure. I'll make.
You go ahead. Go ahead, Amy.
Please know it's funny to hear y'all on the phone from the ceiling.
We're looking up.
Yes, I'd like to make a motion that at this point we vote to approve the Barber program and the Cosmetology program. That we table, and we are not approving the aesthetics program or the instructor programs, both Barber and Cosmetology. We would ask that you would represent the instructor programs and the aesthetics programs in January, but we can vote to approve the actual courses for barbering and cosmetology today. Approving an inspection by the inspector and a board member.
Thank you.
Second it.
And we have a second. Any other discussion? All in favor say aye.
Aye.
Opposed say no. Motion carries. Congratulations.
Very much.
Mr. Roberts, if I could ask a quick question. On your contract at one point where you've got the address, the catalog owner, and understand you have Larry Roberts Jr., instructor, are you licensed to teach in Tennessee?
I should be now. There was a discrepancy and I always renew everywhere I have a license at. I always renew my barber's license as well as my instructor's license. So when Tennessee asked me for my information to make sure I've never been disciplined, I only sent in my instructor's information because the instructor trumps the barber, but they wanted the barber as well. So I had to send that paper in, which I did. So any day now, if it hadn't already been, I should have my instructor certification here.
And you've got a separate cosmetology and barbering. You had one person that teaches both?
Oh, yeah. We have a few people that teach cosmetology and barbering.
Okay. Thank you. So since we know the building is ready, I will look at any minor changes we might need and then send a board member and field inspector to continue.
Mona and Yvette have all sorts of free time right now.
Yeah.
I actually can do it. So it's
Thank you, Mona. You volunteered. I appreciate it.
Thank you, Mona.
Thank you.
We miss
You're
you.
welcome. Miss you too. I really do.
Okay, for those of you here on your iPads, we're moving on to Austin's Beauty College Incorporated, and this is a school extension. If you give me a minute, I'll be happy to have Miss Linda Austin come up. Push that button, okay? Let me get him started.
Certainly. First of all, I want to thank you for letting us present today to you. We are hopefully doing an extension of our campus to accommodate our new school population, which has increased. I have had dental surgery, so I don't speak very well. So my daughter is also the director of operations and an instructor, so she can answer any questions, and she's going to present it to you. Any questions you have for me, I'll be glad to answer also.
Thank you. On your iPads, we have Ms. Austin's presentation. This school has been licensed since 1994 in the Clarksville area. What they're trying to create is a campus training center that is half a mile from the main school building. And that training center is 3,000 square feet. So you have information on your iPads. And then today they brought for you in paper a very professional looking presentation. And so we did hand those out. I have not had a chance to really look at them, but flip through them. So you can use both things. I don't think there's anything there that you can't look at. So they're requesting this extension to provide students with better training and a larger environment. The floor plan is available for you to review. It's really not considered a new school, so it will not be a separate school license. It's not a change of location. Consequently, she really hasn't filled out an application or paid a fee. This is a review for the board to approve so that the students can learn in both environments. And feel free to ask any questions and
This is just an additional space, but it's non-adjacent.
correct.
So we have to approve it.
You do simply because students will be going back and forth, but I'm not sure if you denied it, if they could still do it. The statute says that as a branch of a school that's within that half a mile or closeness can exist, and that would be this case. They're right there. And they're not planning, correct me if I'm wrong, to offer services to the public there. They're going to use this as a training site. It looks very,
Classroom space.
very nice.
Does anything about your existing space change?
The only thing that's changed there is we've put an office in, an extra office, because we've hired extra office personnel. But as far as the layout, no, nothing has changed. We are looking to add a nail tech program next year, so we may have a few changes at that time.
Will you be having just theory classroom over there? Are you going to be doing practical classes as well?
We're going to be doing both.
Okay.
Our whole curriculum is laid out for the beginning students as an 8-week program that's just freshman foundations for both programs to give them a good base foundation.
Motion that we approve.
Second.
We have a motion and a second to approve. Is there any other discussion? All in favor say aye.
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 Opposed say no. Motion carries. Congratulations, and it's a wonderful idea, I think.
Thank you on behalf of Miss Austin and our staff. Thank you.
Congratulations. Thank you. Thank you. Next, we have Paul Mitchell, the school in Nashville. If you'll give me a minute, Mr. Kevin Johnson is here. You know what? He is well familiar with what needs to be done if you've got any questions. So this application that's before you is for a school located in Hendersonville. The business license, curriculum, contingency plan, and student contract, as well as the floor plan that you have on your iPads on page 81 have been received. I'll let you review it. This is a new location, I believe. Is that correct? Yes.
Yes.
So
no
we would be
location.
sending a board member and field inspector.
School, new license.
Yes.
Is this an existing school? Or previously used as a school,
No,
this
it was
space?
not.
All new.
All brand new.
How much, it's massive space.
Yes, 13,600 square foot.
My iPad does not like me today.
Do you have the apprentice program or no?
We are looking to ultimately do the apprentice. We've talked about it for several years now at all of our campuses. So that is one thing that we do want to look at, having that option. We just haven't executed to this point.
Graph and cosmetology and aesthetics.
Cosmetology, aesthetics, and ultimate apprentice in that, and then instructor.
All these policies that I'm looking at, scrolling through, there's a lot. That's just pretty standard with Paul Mitchell schools. That's their.
It is. Yeah.
Make a motion that we approve pending the inspection by the board member and the inspector.
Second.
We have a motion and a second to approve pending inspection by the inspector. Is there any other discussion? All in favor say aye.
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 Opposed say no. Motion carries.
Thank you.
Good luck. Congratulations.
Thank you. If it would be okay with the board, taking advantage of Pamela being here, Pam Spicer, if we could skip to the legal report just to have her explain anything, make sure to put the full committee's decision on the record. Is that okay, Pam?
Yes.
Thank you. And that's a separate item from your presentation, obviously, so I apologize, but I'll give everybody a minute to open your legal report in case you had questions.
If everyone's ready, I'll go ahead and start because I do have some comments that I need to make. This morning, the committee met I specifically went over some of the represents, and I want to bring those to the board's full attention. If I can call your attention to page 15 of the legal report, numbers 47 and 48. The committee approved legal's recommendation, but I want to bring this to the full board that 47 is the owner of a shop, 48 is the shop. This case has been pending since 2015. It was set in December. However, opposing counsel filed a motion to continue and a motion asking the administrative law judge to order mediation. While the administrative law judge cannot order mediation, it was recommended that I speak to my client about this. The committee did approve the recommendation of legal that we attend mediation, attempt to settle this matter, and give the executive director authority to settle this matter at mediation. And we'll need a motion to approve 47 and 48. And there are other complaints that we'll discuss. It's just given the nature of these two complaints, I'm asking for separate approval.
I make a motion that we approve legal's recommendation for these two cases.
Do we have a second?
Second.
We have a motion and a second to approve legal's recommendation on these two cases. All in favor, say aye.
Aye.
Aye. Aye.
Opposed, say no. Motion carries.
The next matters I want to bring the full board's attention to start on case number 49, which is on page 16, and it's specifically 49, 50, 51, 52, 53, 54, 55, 56, and 57. Those are all the same school. First, I want to state that this matter was originally handled by Robin Ryan, who entered into an agreed order with the school. There were certain items that the school needed to perform to be in compliance with the agreed order. There was never a hearing. So now the issue is, since I've been involved, legal deems the school not in compliance with the terms of the agreed order. And these cases date back to 2014, and we have recent visits by inspectors where the school is still not in compliance, and this is after we've even emailed and attempted to schedule a date for the inspectors to come in and inspect the records. So this matter is somewhat unique because the recommendation of legal is that we be allowed to refile the notice of hearing and charges, that the matter be fully litigated, but the issues need to be brought before the board, which is different than what you all have done in the past. Normally, the cases are heard by an administrative law judge. In this instance, we'll be setting this matter, and it will be heard before the full board. The administrative law judge will be present, but the administrative law judge will only be deciding matters of procedure. The board will be making a decision whether it's a civil penalty, revocation of the school license, whatever you all deem appropriate. So you'll actually be sitting, the best way to describe it is as the jury. And I know that this is new for this board, but given the facts and circumstances contained, legal's recommendation is that these particular complaints would be better heard by the full board instead of an administrative law judge. So I also ask for the full board to approve those specific numbered complaints, and I'll need a motion on those as well.
When do you think that this would happen?
The executive director and I have discussed this. One issue is now that you all are not going to meet monthly, it creates a little bit of an issue because we either have the end of January or it would be April. The concern is I have to give specific. Oh, go ahead. Sorry, I didn't hear what you said. I'm sorry.
It's new information to me. I'm not complaining. We're not meeting monthly.
Oh, you all approved that we go down to 6 meetings. So your dates for 2019, if you'll take a look at them, they include just the 6 meetings. After the January 28th, it'll be April, June, August, October, and December. Those are our months, I think.
Sorry, I missed that. I apologize.
So that for legal creates a little bit of an issue as well, because if we cannot get this matter refiled, service, opposing counsel agree to the only date in January, it would likely be April. I'm going to go ahead and say, in my opinion, it will probably be April, because the problem is going to be filing it, serving it, and getting opposing counsel to agree to only the one date in January, which may not provide enough notice to the school and opposing counsel. I guess you all could vote to come in just to hear these cases if you wanted them heard before April. The problem with that is opposing counsel could still file a motion to continue. You all could say, I want it heard in February. I would then give notice on that, but opposing counsel could still file a motion to continue. Those matters are heard before the ALJ, the administrative law judge. Then we would need to still come back and have another hearing date. So it would be probably best, unless you all have a strong opinion otherwise, that we plan on April, if I can get with opposing counsel and it can happen in January. But to be honest, I don't really see how that's going to be possible with this date.
So we need a motion to authorize your recommendation for these specific cases.
Yes, and you're not setting the date. You're just authorizing the matters to be refiled, and you're authorizing yourselves to hear this matter in lieu of an administrative law judge.
All right, I will make a motion to approve the recommendation.
Second.
Patricia Parsons, I'll second.
We have a motion and a second. Is there any other discussion? All in favor say aye.
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 Opposed say no. Motion carries.
I have a general question.
Okay.
This school is still open and instructing. Do we feel comfortable with them remaining open and instructing until the hearing, or is that something that we can also discuss?
We can discuss it. Legal doesn't have a recommendation at this point about what we should do to go forward. We would be setting a hearing in hopefully April. I can't imagine it would be delayed beyond that, particularly if I can get this matter refiled. That way everyone's on notice. If the board has some concern about the school continuing to operate in the meantime, of course, the board's authority would be to move forward on a summary suspension. But again, the health, safety, and welfare would be what is at risk, and does this reach to that level, considering that the school entered into an agreed order. So at the time all of these cases were pending since 2014, I wasn't involved in that procedure, but there was a decision made to allow the school to remain open and comply with the terms of the agreed order. Legal's position is the school is not in compliance, but I would have to think about whether that rises to the level of a summary suspension because of the language that would need to be met to meet the burden on a summary suspension, because that would be the only option.
Similar to a cease and desist.
No.
I mean, they're not in compliance with the agreed order. Surely there's something that can be done on our end to say, we gave you a chance. You're not playing by our rules.
Here's one issue, is that the matters were never litigated. So this was a settlement. It wasn't, the judge never decided the issues. So for whatever reason, there was a settlement reached and agreed order was entered, basically giving the school a chance to comply. Our position is now they're not in compliance, but they've been operating this time during the compliance period. I know that may not answer your question directly, but I think there could be some issues with the summary suspension.
And then we're going to have an issue with problems with the students ongoing.
Correct.
Are we inspecting this school currently?
We have attempted to inspect. And Roxana has been involved in that process as well. We have made attempts to inspect. I can't speak to exactly how many offhand, but I know that I have been involved in one of the requests where we specifically set a date and time to go.
Didn't happen? Is that what you're saying?
I may let the executive director speak to that. What I'm going to say is that it didn't happen. Legal's position is they're not in compliance with the terms of the agreed order by allowing us to come in and inspect the records of the students and provide us with the information we need to determine whether they're even in compliance. So we had a further problem of, let's say we go out and get records, speaking in more general terms. We may not be getting all of the records we've requested, so we can't make a determination how far out of compliance they are because we're not getting all of the information. So the school's just in violation, and what we're litigating is the underlying complaints that were originally filed starting back in 2014.
So how long has it been since there has been an inspection?
Went out, was it this month or last month?
And I'll try to add as little as needed, just so that you have the information we can hopefully answer your question. As Pam stated, we actually went based on an appointment, which is not our process. As anyone that owns a shop or a school knows, we don't make appointments to go and inspect. But we did, mostly out of desperation, just to be able to inspect something. We've repeatedly gone and no students are there. So you can't really inspect a school with no students and no records. And we have done that repeatedly. But to the last inspection, we went on an appointment to inspect, one would assume, all student records. Again, if you're associated with a school, your files are in drawers or however they are, and you inspect all, not just some. We were unable to inspect what we needed to see, and that was recently within the last month. But we've had many failed attempts to inspect.
So how many students does this school supposedly have at this time?
At this time, in excess of 50.
And those students were there?
1 or 2, depending on the day we went.
I mean, if they can't provide the documents that we need to inspect, that's just clearly a violation. I mean, why do we have to see why do we have to see everything to see how bad things are going? If they can't show them to us, then, yeah. I mean,
I think something that Pam said that probably is we haven't really litigated the case. There has not been that day in court, and so that's, I think, what we have no choice but to wait to do.
This is Kelly Barger. Can there be a new complaint opened?
There can be. That's one of the things that we could consider is opening in a new administrative complaint. Of course, then that goes through the process. So right now we have complaints pending. Similar violations. I mean, if you look through the old complaints, it's still failure to report. So we still sort of have the same issue of failure to report. We could open a new complaint. Right now we don't have a new complaint.
Okay, I just meant maybe that would speed it up, but...
Well, here's one issue. If you open a new complaint, then I have to present that complaint, let's say, at the January meeting. then that matter would also have to be set. They can all be set at the same time. I don't know that there's a reason to open a new complaint unless there was some other new issue, which, had we been able to inspect all of the records, there could have been other issues that weren't even contained in the agreed order. Of course, the attempt at the agreed order was to obviously get the school in compliance, which is what we're all trying to do. So we entered into an agreed order to attempt to get the school in compliance, and now the position is the school's not in compliance because they're not following the terms of the agreed order. And I think the point is, had the matter been litigated, we'd be at a different point now. Had the matter been litigated, we could be at a different point now on how we would go forward with a summary suspension or something of that nature. But the underlying complaints haven't been litigated. And I can't speak to the terms, and it wouldn't necessarily be the appropriate forum to discuss the negotiations or what went into why the agreed order was entered.
I have a question, and it's just a random question. Does the board have the authority to not accept hours if a school has not been in compliance with our basic requirements, which is inspect when a person is there, when a representative of the state is there to inspect hours? All hours should be able to be in attendance, should be able to be inspected. Do they have the authority to not accept hours until we are able to hear the full case in April or whenever? In lieu of a summary suspension?
I would want to look into that probably in more detail, and could do that as you all continue your meeting. First glance, it would seem that you could, but I would want to get clarification on that and look at the rules.
Then the students would need to know that that's happening.
Yes.
Because they're being duped, I'm thinking, by going to this school that's not complying. But, I mean, is there any way we could say as a board, like a deadline date where we have to see your records? Or
we can do that. I feel like that's what we've been trying to do. When we refile, we can ask again. I think the problem is, my understanding is we've asked several times. I know that we've asked twice since I've been involved in the case, and that's been more recently, within the last few months.
Could we ask you before the end of our meeting to let us know what all of our options could be, whether we could provide a suspension until we're able to inspect or not accept hours? I mean, I think we would like to know all of the options, primarily with the concern that if you come to inspect my barbershop, I don't get the option of locking the door, I don't think. I'm looking at all the heads nodding back here too, right? That's not an option at your schools.
At the very least, it's professional conduct. They're supposed to allow us access. That's written in the law. It sounds, you were talking about the school with the hours. It sounds to me like if every time we go to inspect, there's no students there, it sounds like maybe there's hours being sold or given. They're reporting hours every month. There should be some students present sometime.
Are any of the students testing?
Yes, ma'am. They're being licensed.
This is Patricia Parsons. How many hours are they showing per month per student? Is it the full 40 on a lot of them, or is it just scattered?
Average. They've got part-time students, full-time students. If from the records, it's a typical school that has a lot of students, not one of our smaller schools.
Okay. All right.
You send out the inspector to see if there's students without warning, sending out an inspector just to see if there's students on campus, because if we've scheduled and there's no students there, are they there? If they're getting hours, where are these students? And my major concern, again, is going to be with the students. If there are students out there that exist, if we close this school and they are just immediately, I mean, we've seen it all the time. People that are 2 weeks from graduation and then have no school to go to. That I'm concerned for the students not having a school and having a school that's being closed. There's just so many issues, but I want to see, do these students actually exist?
And when this case comes before you, you will hear everything else that the field inspector and I have been able to do. Until now, all you're able to know or really hear is we attempted one more attempt at an inspection and had to go by appointment and barely got to see hardly anything of what we would have needed to see, which is we walk in, students are walking around with books, they have kits, they're almost all there. On occasion, some get sick. And we see all the files. We're not limited to files. Any school that is present here has welcomed us in their building and opened their files. We don't normally have to give 2-3 names and just see those, or are just handed some files. We see the files.
I believe we have a requirement that records are kept for a number of years as well. So,
right, 7 years. 7 years worth of records should be there.
I'm with Amy that we just need to know if we have any options between now and whenever this hearing is. We definitely need to have a hearing, obviously, but do we have any other options to padlock this door or whatever just any measures that we can take to protect the students and, to protect anything that's illegal going on, I don't know.
So what I will do is when we finish the legal report, we'll go ahead and finish the other complaints. But when we finish the legal report, you all can continue with your meeting. I will go upstairs, do some research, come back with what all of your options are, let's say before April. I can't guarantee it will be April. I think more than likely it will be in April because that's very sufficient notice on this matter. But if there's anything that can be done before April.
Ms. Seifert, this is Mona Stappenfield. I have a question about the Board of Regents. At the time that our board members' responsibility for inspecting schools was changed to the Board of Regents, would they weigh in on this as far as school inspections and responsibilities as well?
No, ma'am.
Okay.
Have these consent orders been paid?
Not to my knowledge. There was an agreed. So what happens, as you all know, you may give authority again, speaking not necessarily about these complaints. You may give authority to settle or litigate a matter. Let's say you give authority and it's a $1,000 civil penalty. Of course, the respondent does not have to accept that civil penalty, does not have to sign the consent order, and then that's when we get to the litigation stage. Then the matters go before the administrative law judge. The administrative law judge then decides how much the penalty will be. In this particular matter, these matters were never litigated, and instead of a civil penalty, my understanding is this agreed order was entered into. So it's a different matter. The consent orders never were signed because that wasn't part of the agreement.
Let's see what our options are.
Yes, I will
Thank you.
see what the options are, and we will come back to this. But while we're still discussing the legal report, on number 17, these are some things that were brought up during the committee meeting this morning. The recommendation was changed to letter of warning. I do want to state, as this board is familiar, the respondent did provide a response that stated she was providing services in her home at no charge. The issue is the Facebook post may indicate otherwise, so the recommendation was changed to letter of warning. I'm not by any means saying that the Facebook post clearly state this individual is charging, but I think this individual needs to be notified and flagged that she cannot charge for services she's not licensed. Then the other item that was brought up during committee meeting is number 34. There were some questions. I just want to bring this to everyone's attention that when the inspectors go out to inspect, because at this point my recommendation is closure with a new inspection. At the time of inspection, because of the limited information that was received in the complaint, the inspectors will be specifically looking for the information that's necessary on the apprenticeship students as far as where they go to school. We don't have all of that information right now. It's not a routine inspection. It will be more detailed because of the allegations in the complaint. So when I request that an inspection occur, it's more specific than a routine inspection, given the allegations in the complaint, because the inspectors will have that information. If there are violations or issues, a new complaint will be opened. And those are the only things I have for the legal report, other than needing to get back to you on those cases that we've discussed. Do we want to just withhold approval of the legal report until I get the options on the...
Well, we've already moved on those cases
On
for the
the-
authority, so that was approved, so that was fine. Just the recommendations you're going to bring back to us is more informational for us,
Correct.
I guess.
Okay.
We make a motion to approve the legal report. I make a motion to approve the legal report.
Thank you.
Second.
Thank you.
We have a motion and a second to approve the legal report. All in favor say aye.
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 Motion carries.
Thank you.
Thank you, Pam. Thank you, members. If you need to take a break, let me know. Otherwise, we're not that far away from finishing. I will let you get back to your main presentation, and we are on page 112. This is regarding Global Beauty and Barber online instructor course. Ms. Sierra Gordon stated that she would be prepared to present before the board today. I don't know if you know what to do. Thank you. You have before you documentation. If the board recalls, this instructor online course was presented at the June 2018 board meeting. The board had some concerns, asked some questions at the time. They then requested Ms. Rebecca Russell, and thank you, Becky, on behalf of myself, I'm sure your entire board, for the time you put into it. So they requested that she have access to the online system so she could properly evaluate the curriculum, track hours, the material itself, and then report to the board everything she found. So that is what you are looking at, and I'll turn it over to her, and then Ms. Gordon, if you have any questions.
Ms. Gordon.
My first login was on July the 9th at 9:58 that morning. I wanted to go through this not just for the content, but also making sure that the hours match to the state board requirements. So upon my first login, there's a small clock, and I've given you kind of examples. I've taken kind of screenshots throughout, and there's a small clock that appears, and it starts counting down your hours. So upon login, it did not start the clock, and I'm not really sure why, but anyway, the clock did sometime after, I think it was 2 hours and 17 minutes that I had been logged in, then the clock started. So I'm not really sure what that was about, but anyway, so I went through the orientation and the first 5 modules. It said that it would take 11 hours and 5 minutes, and this is including, I think, 8 hours to complete reading the textbook. And I was able to easily just mark those modules as complete. And it took me 6 minutes to work through the first 5 modules. I did go back for content and go back through these modules just to make sure that I was clear about what was within them. Eventually, once the timer did start, there was a mathematics module. And while I agree that mathematics is important to every instructor, not just cosmetology or barbering, but all instructors, this module was a little elementary, I think, to me. The questions that were within the module, and I've got them somewhere within this for you to look at, but the questions were similar to if Ron had 2 apples, Roxanne, I had 3 oranges, how many pieces of fruit do we have? And basic math, such as 93 minus 17. I'm not really sure that that's, assessing us for much, but I continued on through the modules. There are lots of videos from online, many TED Talks, as well as other videos. I've posted some of those for you to kind of look at what what they went through. With the video assignments, there was 3 questions that must be asked after each one of the videos, and they were to summarize the videos, your primary takeaways, and how you will apply these primary takeaways. So those things were with every video assignment. Other types of assignments that were there were journal entries. The journal entries were typically 800 words. It was 2.5 hours are given for these 800 words. Although the clock, as it's ticking away, I often walked away from my desk and I actually left the clock ticking as I went home overnight and came back and the clock was still ticking away. So, like I said, I did go back through and watch some of these videos and try to assess it. Let's see, there was something else. In the rules, it states that there has to be 100 hours in lesson planning and motivation. I was able to kind of verify that there was 2 hours and 58 minutes spent on the topic of lesson planning, but it was unclear about what was considered to be motivation, so I'm not sure that we meet that 100-hour requirement.
Is it okay to address some of the things she said so far?
One more thing, and then, so I did work through, the clock did stop me, so I was blocked after I worked through the first day, and that actually took me through the whole first week of activities. Then it did block me until July the 16th. On July 16th, I logged back in, and then I was blocked again until July the 23rd. So these things that I had completed were supposed to be completed within certain weeks, and because I had completed them all on that first day, then it blocked me. So I had to wait until July the 23rd to log back in and see some of this other information. Week 3 seemed very heavy in assignments and amounts of time. So according to what I could tell there was 24 hours and 45 minutes worth of videos and assignments for week 3, and then on top of that was an additional 7 assignments that had no estimated times. So the average per week, according to the syllabus, the average should have been 25 hours, but this would have been almost 25 hours plus 7 additional assignments. So that may have made that one a really heavy week.
So the first week is orientation week, and you're able to move through that week at your own pace because it tells you about the school, it tells you about the policies, it tells you about requirements, it tells you about plagiarism, it tells you about all the things that are in the actual catalog for the school. So that's orientation because the students don't have orientation on the ground, they have it online. The reason that she was blocked after July 16th going into July 23rd is, as she stated, the course is set to progress a week at a time, a minimum of 25 hours a week. It depends on how each person works. I'm not sure if anyone here has ever taken an online course, but with online courses, you work at your own pace. So where we say it is a requirement for 25 hours a week minimum, it could take someone else 45 hours a week minimum. The clock can continue to go, as we talked about in our last presentation. I think it was June we were here. The clock can continue to go. However, it's not solely based on the clock. It's based on the status bar, the progress. So when Miss Becky says she was able to submit, she didn't really actually submit anything. There was like testing or things of that nature that she had to actually key in before she was able to hit submit, because otherwise it will not accept a blank entry. So with the assignments, as far as the mathematical piece, I can tell you, being an educator myself, hosting continuing education seminars, we have educators that do not know the basics. And the reason that we incorporated mathematics is because I still have educators who I'm having to tell how to grade papers, how to grade tests. If there's 100, if it's worth 100 points, they miss this amount, you need to divide this by this. I live this every day. On top of that, any books, my lady, including our expert educator book, is written on a collegiate level. However, it is written on an 8th grade level. So based on our field and what we call for, we have to keep things basic, because if we go too overboard, it's too much for the participants that are in the field. So after every week, it is locked. If the assignments are not completed, if you hit submit, you can put in anything that you want to. However, you will not get the hours, you will not get the progress, because the words per minute, the number of words in the course have been set to particularly calculate to 25 hours a week. So there's no way you can get 25 hours a week by standard if you have not completed all of the assignments.
Okay, I'd like to say, after hearing all this, I would like to ask, and thank you, Becky, for doing this, because I know it was time consuming. But from your firsthand experience with this online course and with Miss Gordon's, if you will, rebuttal to those statements, would you recommend this course or not?
Salty, I think. After seeing some of the modules that you had to go through, and something that I hadn't said before were that slideshow presentations, if you loaded those, they were set at 30-second intervals. I clocked them, and it didn't matter if there were, a whole list of text on that particular slide, or 3 or 4 words. So if it were just a title sheet, it would progress at 30-second intervals regardless of time. There were several modules that I wasn't happy with as far as the math is concerned. I've expressed myself with math. Also with some of the other ones, one of them was called How to Make an Ugly Classroom Beautiful. There was a video of a teacher in an elementary setting, and she was basically taping construction paper to the walls of the classroom. And I was questioning the relevance of that particular video. There are other videos from YouTube that I questioned the relevance of any of those things. So having gone through this the way that I did, I can't say that I would recommend that someone take this course.
Some of the videos, or majority of the videos in the course, are the same videos that we show in our in-person seminars that we've gotten great reviews on. So relevance for me on an educational basis, for example, how to make a ugly classroom beautiful that Ms. Becky was just speaking on. As educators, we put things in the classroom that enlighten, inspire, motivate, and teach all at the same time. So whether that's certain colors that we put on the walls, whether that's things from the anatomy chapter, whether there's things from the skincare chapter, an educator is responsible for engaging the students. That video taught educators how to keep the students engaged. The lesson is not that it's from an elementary setting, but it's from an educational standpoint, that even no matter what age, we have to keep the classroom inviting and open and welcoming to the students. That was the point of the video.
Are there any other questions? Do we have a motion?
Let me just ask Becky one more time something. Not specifically about the curriculum or what's being presented. Is there a problem with the time issues about being able to get through this course?
The time issues, as far as I'm concerned, now she says that the clock really doesn't mean a whole lot on their end because they're grading based on what was actually done. So I guess if the clock doesn't mean anything to the students, then that brings that to question, I guess. But I did try to figure out, like, of these assignments and of the modules that were provided, did they actually meet the board's rules concerning it? And the one of lesson planning and motivation, I cannot clearly say that there were 100 clock hours in lesson planning and motivation.
That's a relevant point. The 100 clock hours are done in person. 200 hours are done online. The relevant clock hours for lesson planning and all those things are done in person because that's more of an in-face thing. And to my understanding, if I'm not mistaken, the board requires 100 hours in person in contact with the students and with other licensed educators. And that's when we do the actual lesson planning part.
On page 113. The first five modules were estimated to take 11 hours and 5 minutes, and I was able to just click mark module as complete and skip. In 6 minutes, these were complete. Was that kind of to your question?
Yeah.
Keeping in mind, we unlocked some of those modules for her.
I specifically asked at the meeting to not have anything unlocked because of this, because of testing the system. So I asked for it to not be unlocked, and I was willing to take 11 hours and 5 minutes to ensure that, that a student couldn't just rush through this. Now, 8 hours of that was supposed to be for reading the textbook, and while I did not spend 8 hours reading the textbook, I did read a large chunk of the textbook just to see kind of what was required along with the modules as well.
I'm sorry, I thought one of the fellow board members asked that the course was unlocked. I requested and recommended that it wouldn't be, but one of them asked that the course will be unlocked so you're able to get through it and look into it.
This online course, didn't we approve it once before and then we found out there were issues with it?
That was continuing education.
I want to caution, so continuing education requirements as far as motivation, and those are 16 hours continuing education. I don't know that they're the same thing as teaching an instructor how to teach. But yes, you are correct. But that's continuing education. It has nothing to do with this. This is instructor hours. This course that's approved will be the first online course for our individuals licensed for 3 years or more who want to become instructors. Does that?
You get just 300 hours online.
And as she stated, so at least 100 hours they are setting aside for that one-on-one watching students that I would imagine would go partner with the school or the school that she's associated with to do the face-to-face watching students for 100 of the 300. The other 200 would be online. And the content of this curriculum is something that you are looking at as well, even though you're all not viewing it through Ms. Russell, just because these are the teaching methodology and the hours that they will need for the exam to teach moving forward.
And what they don't accomplish or get online, they will have to come into the school to complete. So there's no fly by night, if you will.
I so badly want to see this work.
So do I.
Because clearly lots of schools opening, would love to see more folks get into the instructing portion of this industry. I guess, Sarah, you have to forgive me. I've never worked at a school and I've never taught. Do you offer this course in person at your schools currently?
We do.
I would love to see, and again, forgive my ignorance, a side-by-side comparison of your in-person curriculum versus your online curriculum to understand what it is that's going on if I were to attend your school in person for those 300 hours.
Yeah, I think that's fair.
I would imagine the curriculums are trying to match up.
Absolutely.
There are some hurdles when you move it to an online platform.
Yes, ma'am.
I think
This is Kelly Barger. Oh, sorry.
Go ahead.
This is Kelly Barger. I'm sorry, it's hard when I'm not there, but I do have a question, and that is, what is the fear with how this information is received and dissected. I mean, will these potential instructors, they will still have to come before, the testing people and take their test and exam and pass or fail, correct?
Yes.
Yes, Ms. Barger,
So
they will.
are we afraid they're not going to learn the information?
I think it's probably more a question of making sure that it's a level playing field, that someone who's taken these courses in person is required to sit physically in the classroom for the required amount of time and go through whatever learning process is there, versus if they're accessing this through an online course, are they able to shortcut the system and not invest the required amount of time actually participating in the coursework? So, if there's a lesson, for instance, and this is just hypothetical, if there's a lesson that is supposed to take 10 hours to complete a segment or a lesson online, and through technological knowledge, people are able to shortcut that system and cut it down to 5 hours, then that's not what the real intent of the requirement is. We want people to actually receive the quality education and not just pass over, not just move through something by clicking buttons. So I did not review this one, so I don't know what this one is like. But I think that I'm trying to address your question on what the fear would be. It's making sure that whoever's participating is actually being held to the same standard as the classroom.
I understand. Okay, I understand that definitely for the instructors who are required to sit through a certain amount of hours. I do understand that. But if someone's passing the same exam, whether they sat for 20,000 hours or 2, does that matter?
I think it really does, because if you could apply that to a full cosmetology or barber program and say if someone is just lucky at taking tests, then they could simply take a test and score the minimum score and not attend any classes and not attend school anywhere just because they're good at gaming a test. So
the great thing about
the fifth grader is.
The great thing about the online course, it is instructor led. So even when Miss Russell first got on the course, an email was sent to her by technical support that was not responded to because she was moving through the course pretty rapidly. We asked, was there anything that we can assist her with? It's kind of hard to measure something as far as timing when you go in and just put in testing or state board review. None of the assignments were done completely, and honestly, we did not expect her to do that. However, an 800-word research paper based on the topic that they have to write on, I can assure you it has to be an MLA format, if anyone's familiar with that, or APA format. They have to cite, reference as well. That is not something that you can do in a matter of minutes.
I'll just say one more thing because I know it's weird coming from the ceiling. So maybe this will just give us a chance to kind of start grasping the fact that, more and more things and information is going to come to us by way of technology. And however this works out, one way or the other, we'll at least have this under our radar that these are things we will have to figure out in time to come.
I would like to say that I'm not against having an online instructor course. I'm actually part of the Digital Engagement Initiative for the state of Tennessee. So I think that things are going to a digital and technology is huge. I just want it to work properly and making sure that they are getting the hours that they're intended to get, and that the information that they're intended to receive, that they've received all of that. And I'm just uncertain at this time that this course is going to work the way that it's supposed to. Again, I hope that we can get it out there because it is important, and I don't think that the instructor course is taught enough in the state that we're able to meet those needs. So I want this to work. I'm just not sure that it does.
The
Hey,
information.
this is
Go ahead.
this is Yvette. This is Yvette Granger, and I'm echoing a little bit. And I was just listening to everything that was being said. And it just seems like the hours are just way more important than the testing or anything else, in my opinion. But I feel like 6 minutes, of course, is extremely too short to retain any information. But if something is done in, I guess, a timely or appropriate manner in that particular subject or topic, then it seems like the students should be able to move on. But by law, we have to go by hours. Because the online course, I'm starting to get confused for exactly what it's for. Is it for a student just not to be able to be in a classroom, or is it for the convenience of being able to do that work and that lesson at home after work, or, with the children being at home, or whatever the case may be? Because ultimately, the online course, that's basically just like going to school. You have to put in that amount of hours. And if that student doesn't realize that they have to sit there for that amount of hours and do that work, those hours got to come from somewhere out of that 7-day week, that system will fail, because that understanding may not be there. On one end, it's like, okay, I'm going to retain this information and get everything I know. But it may not take them 20, 25 hours or even 40 hours to retain it. They may get that a little bit quicker because they are sitting there reading and doing what they need to do in the amount of hours that they dedicate to that particular topic. But then if they finish all those courses and they still got 25 hours to complete, then how is that handled? I'm just a little confused.
They have to come in. They have to come into the school, Miss Yvette. That's a great question. So let's just say, for conversation's sake, they get less hours than they were required to get on the online portion. Whatever is remaining that they did not get, they would have to get those at the school. Everybody has to come through the school. There's not a person who can complete without coming through the school, if that makes sense. So whether or not they were supposed to get 100 hours after the online portion, if they were lacking 50 online, they're going to have to get those 50 additional at the school before we can even submit them for their testing or anything.
Can I log on and leave the clock running for those additional 50 hours?
The hours are based on work. So, for instance, your status bar show that you completed less than 8% of the course. So even though you're saying, I got these hours, as a teacher, as an educator, if I go on and see you haven't submitted the work, you haven't done the work, you don't get the hours. You cannot get the hours without doing the work. So even though you're saying, hey, I let the clock run for this amount of time, your status bar shows you did 8% of the work out of 100%.
That's it. I'd like to correct that. I've got a screenshot that shows that my course progression was at 35% at 102 hours.
My apologies. The last time I looked, it was at 8.
I have a question regarding TED Talks and YouTube videos. Do we use those as supplemental education in most schools? Those schools I visited, they're supplemental hours. They're like to add on top of. So my question, it's more a question than anything else to the board members. If this is used as a good portion of the curriculum and the true education learning, is that okay with the board? Because, and I've taken them both. I've done YouTube and I've watched TED Talks, and my team does, but we consider it kind of over and above, not the basic. I guess that's what.
I think anything that's information that's communicated well is beneficial. The board's approved reference, though, is the textbook. So I think that any good classroom is going to utilize all kinds of different tools in different ways. Would that be a mainstay, focus on something that I'm working on in my personal school? I don't think I could let that be the teacher for me. That's something I might use as a little bit of extra information, extra engagement, somewhat. But again, that's different teaching styles too, I guess.
I can see that you would use those in continuing education, but I think I have two questions. The is the Are the standards of the curriculum being met on the online course as as well or the same as the classroom traditional method of teaching the instructor class? And also, is there a way? Or, I didn't take it. I don't know exactly. But if I'm watching a video, I'm hoping to get some information out of it that's going to benefit me and teach me something. Do you have an online way? Like if I just walked away from the video and went, to the other room and took a shower, came back when it was over, are you going to know by follow-up questions or something? Because all I saw in here was it just said, give me your opinion of the video you just watched. Well, I can BS that.
That's a great question.
All day.
And the first question that it asks for after every video is, give me a summary of what you saw and what you watched. What were takeaways from what you watched? And how would you use what you took away? Those are the three standard questions after every single video.
I see that right here.
And then you have to type it in the box below. Based on our syllabus that was also in the course, we ask that you type that in a certain way. We ask for a number of words and a number of sentences. So you can't just go in and type, I thought it was great, period. I got that I should be an awesome teacher, period. It requires detail. It requires critical thinking because it is an instructor's course. It's not a cosmetology course. It's not a barber's course. It's an instructor's course. So the format is different, but it is very similar to the course that I've taken for the University of Phoenix or Bethel also.
So if I watched the video about how to make your classroom beautiful and say I didn't really watch it, I went shopping, came back, and then I'm looking. I summarize it as it was a teaching video on how to make your classroom beautiful, how you can add color on the walls. You can, and I just go on and on. Who's going to grade that? And where are you going to say? How are you going to know? Like if I'm in a classroom, you're going to know if I'm watching it.
The instructor that is over the online course, remember we were talking about it being instructor led, they have to evaluate. It's a grade book. The instructor gets a grade book, the student submits it, and it goes to that instructor, and the instructor has to grade everything that they hit submit for. Everything.
I have one more question. This is Kelly Barger. So are they going to be tested to get their instructor license on how to decorate their room to make it beautiful?
They will be tested on motivating the student, yes.
To get their instructor license from the board?
Yes, that's one of the standards on getting the instructor's license.
Okay. I think the hard thing for me is that this, in general, not your course, this is all based on the number of hours that you complete. And I know I've been to plenty of schools that there are likely a lot of students who finish early or get done, and they're not actively learning for the full 300 hours. So I don't expect, I don't know. I'd like to see this be given a chance, but I don't know if there's a way to do that. I don't know how to do that. Is that an option? I mean, I know, unfortunately, Sierra, in the past, we had the 16 hours that didn't work. And we had to roll it back. And I know we don't want to roll back anything else. But I like the fact that this is paired with an actual school, that there are in-person hours as well, that it's not entirely online, of course, as a trial period. Is there a way to do that?
This is Kelly again. I'm sorry. I can't keep my mouth shut. So, if we were going into classrooms in brick and mortar schools and, analyzing how many hours the students were looking at the teacher's face or, how many hours they were doodling on their paper. Not that I ever do that. It's hard to really measure these things. I mean, I think we measure them by how many students pass their course and how many students pass the exam is usually how we measure that.
Okay. Do we have any other questions?
Yeah, I have one more. I'm thinking about this, make your classroom beautiful. Do you do that in your traditional method of teaching this class, the instructor's class?
Yes, we actually do, because how the classroom is designed, how the seats are arranged, whether they're semicircle, whether they're theater, that's all a part of the classroom. That's all a part of how you keep your students engaged. For example, how you all are sitting in this square normally, that's something we don't do in the classroom because it's considered inappropriate seating. So all of those things are designed to teach the students not only what they're supposed to do hands-on in the classroom, how they're supposed to reach the students, how they're supposed to engage the students, but those are some of the questions that are on their exam.
What are the differences in your traditional classroom instructor course and this online one?
There isn't any difference besides the fact that I will be standing in front of you teaching you the same things.
I would agree that seating arrangements are important in the classroom and knowing the different seating types, but this was literally cut and paste construction paper, and there was no direction given. It was just some background music and an instructor in an elementary classroom cut and pasted construction paper on the surfaces of the classroom. There was no information given. It was just music, and they did it in a speeded version of that, and that was it. There was no arrangement of classroom. There was no, why we're doing this. It's just the video.
That was actually in the literature on why they were doing it, why they needed to have the classroom a certain way. That was actually in the textbook.
This is Patricia Parsons, and I've been listening, and I think the online is the way everything will go eventually, but I think we need a program that is going to work. And I know that Rebecca does such a thorough job on evaluating, because we all want everyone to succeed in it. And with her opinion as what she's given, I would have to make a motion to deny and maybe come back with a plan that will work according to the laws that we have in place.
So do we need to remove the beautiful video?
You have a motion.
We have a motion on the floor to deny this application at this time. Do we have a second?
I will second it. This is Mona.
We have a motion and a second to deny this at this time. All in favor, say aye.
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 Okay, I tell you what, we're going to have to do a roll call. We're going to do a roll call.
Thank you.
So,
as I read your name, just let me know, please, if you are in support of the motion, which is to deny. So a yes is in support of the motion to deny. Ms. Kelly Barger.
No.
Ms. Nina Coppinger.
Yes.
Mr. Mike Gillihan.
yes.
Ms. Whitebeck Granger.
No.
Ms. Judy McAllister.
Yes.
Ms. Janie Ross.
Yes.
Ms. Patricia Richmond.
Yes.
Ms. Becky Russell.
I abstain since I was the only one on the inside.
Thank you. Ms. Mona Sappenfield.
Yes.
Amy Tansley.
No.
We have 6 yeses and a total of 1, 2, 3 noes and 1 abstain. So the yeses have it. The motion carries. It is
Motion
denied.
carries.
Thank you.
if the board will, I know that Pam is back for the legal report and the update. If you need a break, again, let me know. Otherwise, we'll finish up and get caught up afterwards. Thank you, Pam.
I went upstairs, spoke to Chief Counsel because this case started before I was with the department back in 2014. I'm going to let him speak. I did inform him that you all are wanting to know your options. You've approved the recommendation as far as you hearing this matter, and that it will likely be April. But in discussion about what your options may be, he wants to provide some additional insight on that between now and the time of the hearing.
Good morning, everyone.
You just thought we were going to leave you alone.
No, I knew that everything was down here. Had I been watching on the video upstairs, I would have come down earlier. I apologize. I was in a meeting when Pam told me that you all had some questions, so I'll introduce myself for you all and for the room. I'm Tony Glandorf. I'm the Chief Counsel for the Regulatory Boards Division here at the Department of Commerce and Insurance. Ms. Ross, welcome to the board. I know that you're a new member. I actually coincidentally learned last week while I was in Fort Bliss, Texas, that I actually worked for one of your sons in the National Guard, because I'm part of the 194th Engineer Brigade, and he's our commander over there. So welcome to the board. From our perspective. So I think you all had a question about last minute cuts, about the issue that Pam brought to you today. It's my understanding that that what she brought to you is an agreed order that we had previously entered into with last minute cuts in September of 2017, and that order was in lieu of going to a formal hearing, and that order provided some assurances to the board that they would be in compliance generally with most of the laws and rules regarding the schools that they have. And it's my understanding that the issue that we've run into for the last several months is that we've had the inability to go in and actually inspect the school like the order says that we can, and that we've been trying to do. And it has gotten to the point where I think that we have just been absolutely stonewalled, and it's concerning because we're trying to go in and audit or look at some of the records. And I'll just leave it at that because we're in a public meeting. We probably don't need to discuss the particulars of it. But in general, we should be able to go in there just like we do with every school, and we can't do that. So what Pam has brought to you is basically that information, and provide that to the board so that we can take further action based on that. That order in there doesn't have a so what clause. It doesn't say, if you don't let us inspect your schools, this is what's going to happen. So there's not a so what involved in it. Most of those cases that were involved were 2014, 2015 cases. And I remember that when that order was being entered into, that there was what we called very unripe cases that were several years old. And so this was the idea of this was that we were going to have like a fresh start, kind of come anew, and the agreed terms. With last minute cuts, they had an attorney that represented them, and the assurances that we were getting is that this is what we will abide by. So this is kind of a contract that we have between the two. And to the point that we can't actually go in and inspect the schools, it's very concerning to me. And so what do you do about that is that there is a violation of not agreeing by and not adhering to the orders of the board. And so this is an order of the board, and they're in violation, we believe, of that order. So an appropriate measure would be to open a complaint and then take action based on that. And that's what we've done. I think the concern is the timeline involved in that. Is that correct? And then kind of like, is there a stopgap or something else that can be done?
For this, is there anything that can or should be done at this moment in time, seeing that they're obviously in non-compliance for the past issues, but it is still an ongoing issue with them refusing to provide records for the board is pretty serious.
Right. Yeah, absolutely. It is a serious thing. I think that there there are other options that the board could do that has to do with trying to do a formal hearing a little bit quicker, wherein I believe this is the type of case that you all would want to hear before the board, which you have the authority to do absolutely in the past. A lot of these go to the administrative law judge, but something that has to do with the technical nature of the school, I think you all absolutely have the proper and correct insight into weighing what is important and how serious those violations are. And I think the idea was that you would have a hearing on this, potentially scheduled for an April time frame, and that may be too far out. Now, this board can always, in conjunction with our office, look for dates we already have approved that we could get a judge available, and you all could specially set and come in for a special day just for a hearing outside of your regular meetings. That would be something that I say is an option. That would be something that we would have to speak also with the administration, with Roxanne on, because there's an expense involved in you all coming in for a special meeting for that and all. But, I mean, that could happen between now and April. I say we can schedule anything. Oftentimes we do run into the issue that we can't control of continuances being asked by respondents who get attorneys last minute or whatnot. We don't control that. The judges control that, that decision. So there's the option of doing that. You could always, and I know this may be a great case for you all to hear, but you could always authorize us just to hear it in front of an administrative law judge only between now and that time frame. And I think that's probably not the option that everybody thinks is the best kind of option out there. You all would be able to review an order that administrative law judge issued out. But I think that may not be kind of what you all want to do. But those are a couple options out there. I think I heard the question earlier as to whether or not a summary suspension would be appropriate for this type of matter. And I will tell you that from my perspective in reviewing what the law requires for summary suspension, there has to be an immediate and irreparable harm to the public. And I have a lot of difficulty finding where that would be in this matter based on how we have viewed that in the past. I think there are potentially some issues that we may run into with the reporting of some of these hours, but I don't see where there would be an immediate and irreparable harm. And there's an ancillary issue to be resolved, is that there could potentially be, if we did that, an unintended consequence to some students out there, about students who have actually have some hours that they have accumulated that they need credit on, and where we would potentially be affecting consumers out there in the public. I think that would be a very difficult thing to do, and I think that that the board could be scrutinized in a bad light for something like that, especially if we found on the back end that some students had been affected by that. So based on that, I would not recommend doing a summary suspension based on the facts that we have in front of this. And I had reviewed this, I think previously last month or the month before, and we went through some options, and I sat down and had some conversation with Roxanne. And Roxanne, I don't know if we actually talked about summary suspension. I can't absolutely remember that, but it wasn't something that I expected from this matter, because at the end of the day, we all know, and I know that you all have so much insight as to how this industry works, is that the potential harm that could be out there. But on the face of it, what we have is the inability to inspect a school, is the face of it that we have. If we had something more, allegations that were more recent that we could point to and had somebody who could provide us with a sworn statement with a consumer or a student, I probably wouldn't be saying that right now, but I don't have that. And I say, and my recommendation is based on, I'm trying to see what is best for the board and to protect you all on part of that, because the summary suspension is a serious matter, and it ramps everything up a lot to another level. And so that would be my recommendation on that. I'm sure you all would have questions.
So lacking a fresh complaint that indicated some other serious endangerment to the public, then our best course is probably to wait and let this schedule out in the way that we discussed through April.
Yes, that's what I would say. It would be, you could do it at the April time frame. If you all wanted to have a special meeting to have a hearing before then, that you all would be available and we could coordinate, we could do that also. But other than that, yes, it would be April, and I know that may seem like it's a slow process to do that. And I will say is that generally litigation in the administrative sense takes a lot longer than most people would usually like it to be. and it's something that we can't affect a lot of the timeline on that, unfortunately.
Members have any other questions?
Repeat that. No, I'm just kidding.
I'm
just kidding.
Thank you.
All right.
Thank you.
Thank you very much, Tony.
I think we voted already as a
We
full
did.
committee, so if the board is satisfied with that, we will go on. Do we need to take a quick break? We probably have
Yeah, I
another
think
hour to an
we
hour and
probably
a
got a
half.
little bit more to do. 15 minutes or so?
15
10
minutes? Okay.
10's right there.
10.
10? It's 12:10. We'll reconvene about 12:20 in 10 minutes. Thank you.
Okay, I'm here.
Thank you. We are back on the record, and we have participating electronically Ms. Yvette Granger and Ms. Patricia Richmond. Are you both there? Ms. Granger
Yes, I'm here.
and Ms. Patricia Richmond?
Yes, I'm here.
Okay, so we still have quorum. We will proceed. I'll give the board members a minute. We are on our applications to test. And on your iPads, that is on page 121. For this meeting, we have one application from Ms. Shirley Allen. Ms. Shirley Allen is currently incarcerated. She is asking the board's permission to take the Tennessee examination. She has provided the disclosure information, letter recommendation, and in this case, it has to do with her actual criminal case. The board on these always does a 2-year probationary period. Once the agreed order is received, we proceed with allowing the exam and then licensure. If you have any questions, I will need a motion in order to approve her.
Roxanne, I'm back. This is Mona.
Oh, thank you, Mona. We appreciate it immensely.
I make a motion to approve her with a great order.
That's Ms. Richmond. Thank you. And Ms.
second.
Judy. Thank you.
We have a motion and a second to approve. All in favor, say aye.
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 Motion carries.
Thank you. Next, you have a request for an approval of a manicurist license for Thai Ong. Ms. Ong has attended one of the schools in Georgia that is currently under investigation and not accepted by the board. She completed an application to test and was entered by the board office prior to the complaint and the current situation being presented to the board. Ms. Ong has passed her practical exam. That was on August 28th of 2018 and is now requesting her license. A couple of other applicants were in the same situation and also approved.
Make the motion to approve.
Second.
We have a motion and a second to approve. All in favor, say aye.
Aye.
Aye. Aye.
Motion carries.
Thank you. Next, we are on to our applications for reciprocity. First application is a cosmetology license from Illinois. This license is for Landis Jackson. Certification shows an initial licensure in September of 2016. That license is listed as a probationary license, and that is on your iPads on page 139. The initial licensure date is September 30th of 2016. And that probationary period lasts through October 31st of 2019, so it's actually not an active license. Illinois does have 1,500 hours and both exams comparable to Tennessee. The consent order is provided for your review. The charges and his background are all there. It appears to be a situation similar to the agreed orders that Tennessee does for probationary period, with the exception that Tennessee does not list the license as a probationary license. We consider it an active license with a recourse should something go wrong. Given the current situation that it's under the 3 years as the statute requires for us, I would recommend that we provide an agreed order as well and have them be in a 2-year, or if the board chooses less than a 2-year probationary period. But his license in Tennessee, if approved, would be an active license. We would just have that recourse.
I make a motion to approve with recourse.
Second.
For Patricia Parsons.
We have a motion and a second to approve the recommendation. All in favor, say aye.
Aye.
Opposed, say no. Motion carries.
Thank you. Next, we have an application for reciprocity of a manicurist license from California from Miss Misty Minks. The certification from California shows an initial licensure of October 1998. Ms. Minks does not have a copy of her transcript because it's been such a long time, and the State Board of California, similar to several others, only maintains records for 5 years. A letter from her employer states that she worked at...
We check our mutes, please.
Yes, if we could please put the phone on mutes, I really appreciate it. Thank you, board members. The document provided states that she worked at Asante Spa between August 2006 and October 2008, and then again between April 2014 until recently when she moved to Tennessee. There's a gap in time that she explains in her letter is due to having a child, and she's moved to Tennessee. The board had asked when we couldn't get the transcripts for the 5 latest years of experience, and then we could approve in the office. Because they're not the most recent years, I was unable to approve, but my recommendation would be to approve her for reciprocity.
Motion to approve her for reciprocity.
Second.
We have a motion and a second to approve reciprocity. All in favor say aye.
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 Motion carries.
Application for reciprocity of a cosmetology license from Florida for Constance Pippin. The certification shows she was initially licensed on June 21st of 2013 with 1,200 hours and no practical exam. She is also licensed in Michigan since December 13th of 2017. Her written communication states that she was originally licensed in Florida in 1989. And that she has been working since then. She has no work experience for the last 5 years because she's been taking care of an ill family member. Florida does change the licensure date. That initial licensure date is changed if a person fails to continue renewing. So that is a possibility. However, all they certify is the 2013 date. My recommendation is that she take the practical exam.
Make a motion that she take the practical exam.
Second.
Second.
We have a motion and a second to take the practical exam. All in favor say aye.
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 Motion carries.
Application for reciprocity of a cosmetology license from Florida. This license is from Ms. Linda Traylor. The certification from Florida shows an initial licensure of December 1986. The California State Board has provided information to Tennessee as well as other states regarding concerns on a long list of schools. Since that time, all applicants from California have been asked to provide their transcripts until the investigation is complete. Ms. Traylor is unable to provide her transcripts. She did provide proof of work experience going back to 2004 through 2014. She does not have anything more recent. My recommendation is that we approve her for reciprocity.
Motion to approve her for reciprocity.
Second.
We have a motion and a second to approve reciprocity. All in favor say aye.
Aye.
Aye. Aye.
Motion carries.
Last reciprocity applicant is an applicant for a cosmetology license from New York for Katie Trickle. Certification shows Ms. Trickle was initially licensed in October of 2013. New York only requires 1,000 hours, but she would have taken both exams. The actual certification has not been received yet, so what you have on your iPads on page 178 is the copy that we've been able to pull online. She has provided proof of prior military orders to explain the lack of documentation regarding some of her work. She was able to start working in the state of New York since 2011. She has presented tax records, a letter recapping her experience, and an explanation of the missing supporting documents. My recommendation is that we approve her for reciprocity.
Make the motion to approve.
Second.
We have a motion and a second to approve. All in favor say aye.
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 Motion carries.
We are on to our miscellaneous applications now. The first one before you is a request for an extension of continuing education requirements for a master barber instructor, David Highland. Pursuant to Tennessee Code Annotated 62-3-124, an instructor must complete the 16 hours of an approved training course. It is at the board's discretion to approve up to one additional year extension for good cause. Mr. Highland emailed explaining that he paid his renewal fee timely, but had a multitude of personal issues going on and had missed attending a session. He's obtained his instructor license in 2014 and attended sessions in 2014 as well as 2016.
Make a motion we grant him his one-time extension.
Second.
We have a motion and a second to grant the one-time extension. All in favor say aye.
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 Motion carries.
Next, we have a request, and this letter is on page 195 of your iPads. This is a request for approval of a continuing education session completed by cosmetology instructor Ms. Laura Mullaney. Pursuant to Tennessee Code Annotated 62-4-114B, an instructor may notify the board to place their license in inactive status. Before getting her instructor license back, an instructor that has been inactive must complete a training program. Ms. Mullaney obtained her instructor education and her license in 2001. She is under the impression that she placed that license on inactive status. Records from the board office include that she was to be presented in December of 2005 to ask for an extension, and then the instructor part was removed. I have gone back and looked at everything possible, and she is definitely of the opinion that she went inactive. There were a few years where she paid the additional fee to go inactive, so at this point I can't see a letter that says she did, but she definitely continued under that impression. What she has provided is courses that she completed. She has a job offer, and these courses were provided at the school where she is working, not as an instructor, but working there until she can take on that. And she has completed, I added these, I believe it's 18 credit hours. So we have a couple of things. The fact that the records don't clearly indicate she went inactive. They don't necessarily show that she missed it either. So we can go under the assumption that she had every intent in 2005 to place her license on instructor, inactive status, and now needs to take the course and go with that and then decide if these courses are acceptable. If not, she could take the exams and start working in 2 weeks, or wait till the next course, which I mentioned to her is in March, I believe.
Did you say that she had paid a fee for?
She did. The inactive instructors still maintain and pay the instructor fee.
Okay.
So the first 2 years, it was a clear accounting correction that added the $10. So that would lead me to believe, with it being a different technology and a DOS-based system, that it was likely a manual correction to have her pay for the inactive. And then at some point dropped.
I think her belief was probably clear that she was inactive.
Yeah. So secondly, then, we review these documents. At least since I've been here, we haven't approved a session that isn't one of the sessions the board normally approves. I believe you have the discretion to review this and decide whether it's acceptable for the 16 hours, in which case she could start teaching tomorrow, need be. If you do not, she has the option, again, just to test or wait until the March session. I'll leave that at the board's discretion.
This program we're looking at is not a previously approved program. This is just an in-house thing they did in their school.
Yes. It's got the topics. I spoke to the school itself. It's done by Pivot Point, which, as you know, is one of the books that we do. But again, since I've been here, at least, we've not presented something that isn't approved each year. That doesn't mean this isn't better or worse.
Is it required that she complete the CEs before reinstatement of her license?
Yes. That's actually in that Part B, must attend an approved session. So given that she can't, because there's none offered right now, there's nothing online, it would be at the board's discretion today to approve these hours to give her the 16. Or if you can't, she has to wait till the first session is being offered.
I've taken these Pivot Point courses, and just as a point of reference, this is very similar to the My Lady textbook that instructors use. So that's the type of information she would have gained, is the typical what they would have learned going through their original licensure.
Would you positively for the CEs to count?
It's an excellent course. I'm trying to think, like, what is the requirement for what are the subjects that we have to cover for those CEs? There's no
Teaching
requirement.
methodology has to be included. That is really
Then
what
yes.
you would recommend.
That's your motion.
I'm familiar with these programs as well. I'm pretty comfortable with the fact that they are all about teaching methodology. So, retroactively kind of approving this program is the only thing that is a question in my mind, and perhaps in this limited, situation, it probably would be appropriate.
And it would be just for her. Now, we may have other inactive instructors, then would this president present it? I've had a few ask in the past, and their courses didn't come close to anything. It had nothing to do with teaching methodology. I looked into the school because I didn't know about the curriculum to find out, and would have to second what Ms. Russell has said, that it is definitely along the lines of what we would require.
How many years has it been since she's been inactive? You said 2005?
The last course she would have attended would have been in 2003. She didn't get to attend in 2005 again. That's where the question, she went inactive versus actually, just gave up on the license and didn't keep up with it. But if we're going under the assumption that she was inactive all this time, she hasn't had any continuing education. Now, I personally spoke to her simply to get some more information. She's not been teaching students, but at least from everything that she has said, she's still in that teaching mode. And so this is an opportunity for her, but she's been outside of the industry.
It's been such a long time, to take the test. It shouldn't be a difficult thing for her if she's up to speed on everything anyway.
Now, if an instructor goes inactive, we would never put them back to test. And they could always, obviously, but we wouldn't, as a board, send them to test. We'd have them complete the course.
You just have to take the
course. So the question then, since we're going under that concept, she was inactive legitimately, is does this course count toward the CE? Because she has completed it. This isn't future dates. She's already taken it. She took it in October, really thinking, I'm good to go now. Asked for her instructor license and we couldn't give it to her. So do we count this as the 16 hours?
First available class coming up, is it March?
It is March. It may be April. It's March or April.
Can we make a note, if we make her active today, that she would need to take a pre-approved course this year?
Absolutely. Yeah. Absolutely.
To get back on track, so to speak.
To get on track. That this would allow her to come back to active, showing she's taken some education, but that the board would require her in 2019 to take 16 hours.
Want to make that motion?
Sure. Let's make a motion that we approve her license today, but that in order to remain active, she needs to go to the 16 hours in 2019.
I'll second that.
You've heard the motion. Is there any other discussion? All in favor say aye.
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 Opposed say no. Motion carries.
And we're leaving 2019 the entire year, not limiting her to the first ones. Perfect. Thank you. Next is a request for an extension of continuing education from a cosmetology instructor, Ms. Taylor Dawkins, pursuant to Tennessee Code annotated 62-4-114. An instructor must complete 16 hours of an approved training program. It is at the board's discretion to approve up to one additional year for a good cause. She planned to attend the session in October, but that provider canceled the courses, as the board is aware. She's obtained her instructor license in 2012. She attended in session in 2014 and 2016. This would be her first request.
Motion that we approve her request for extension.
Second.
We have a motion to approve the request. All in favor say aye.
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 Opposed say no. Motion carries.
Thank you. Next we have our financial information. And this is for the total of 4 months so far in this fiscal year through October. I don't want the board necessarily alarmed. We ended October with a negative 7,614. September also ended negative. Those 2 months.
You go on vacation again.
No, I didn't. Promise. I've questioned in every one of the other 14 programs I have. They are high because of a lot of our technology bills. That's when they came due. This would be just the regular maintenance, some upgrades. And so the cost back fee is higher, and we are going to, moving forward, have a separate line for those technology lines, if you will. I don't foresee that this is going to in any way change us going forward because they are unique invoices that hit in those 2 months. So I'm not overly concerned. Nevertheless, as we've talked about it, we did a very minimal fee increase with the thought of not going in the red. However, not having abundant funds. Our cutting back our meetings is going to make a difference just from a travel perspective. We're from 9 to 6 meetings, so we'll see some changes there. So I think we're still okay, but definitely wanted to put that before the board.
I mean, why is Roxana, were those tech charges same time frame last year?
No, some of these we did last year. We had very minimal technology things. We did a large upgrade from the basic core that we expended in 2015. So we ate the majority of our financial costs for the technology rolling to this web browser system in 2015. We haven't seen a bigger one until this one. This was a big release. So I think it will level off and we'll get back on track soon. It puts us at a negative for those 4 months, but again, it's if you look at $2,800 when we bring in about $2 million and spend about $2 million, I think we're still going to be okay. If there are no questions, and I'll give you a minute to look at those. I know it's a lot of information. We are on to new business, and I think most of this is updates, not just new business. One piece that is new to the board, and I put that email on page 221. The board had repeated follow-ups with the University of Memphis to determine if they were interested in offering the instructor course. At one point, they had even discussed possibly the online session being provided. Mr. Roy Bowery responded, and this is thanks to Betty's efforts. I failed to get emails or calls back, so Betty had to actually help and tackle it on a daily basis. But we did get a response stating that the position of the coordinator that does continuing education has been terminated, and so they will not be pursuing doing continuing education on behalf of our board for 2019. So as soon as this meeting ends, I am going to update the continuing education session, put them online. I was really holding back for the University of Memphis, which is such a large one. And then similarly, we have left, I personally, repeated voice messages, emails. Betty's helped me. She too has unfortunately failed. We have heard nothing from TSU on their interest or lack thereof for the 2019 session. So I'm going to remove them for now. That does not say that they can't tomorrow present something and we bring them before the board. But for now, we're going to publish the 2019 dates short of those 2 big sessions.
TSU had some turnover in their coordinator as well from last year.
She was new last year. Do you think she's gone again, or we have somebody?
I think she was the young lady in charge last year was moving up to a new department.
Okay.
So,
well, voicemail still works because I've still left messages and her email.
I moved it.
But yeah, we've had no success there. Not even a no, we can't do it anymore. So I think for now we remove them so the instructors have an option, have a clear path, and if we add them, then that's perfectly good. There's nothing to say that they can't be added. Then on page 222, this is an update. The California State Board, as the board is aware, opened an investigation into schools. You'll see on the spreadsheet we've created, we started out with 22 schools under investigation. On November the 26th, the Deputy Director for the California State Board emailed and cleared 6 of these schools. And so the ones with a date there have provided for California records of anything that California asked in that investigation, and they have in turn let us know that these schools are okay, not suspended, revoked, nothing was opened against them. So I would at this point like the board to motion us accepting hours for those 6 schools or decide how you'd like to handle, and the investigation may continue however long. We have no control over that.
The motion is that we start accepting hours from reciprocity applicants who have attended these 6 schools.
Correct.
That's my motion.
Thank you.
So we have a motion. Do we have a second?
Me, second.
Oh, second. I'm sorry. All in favor, say aye.
Aye.
Opposed, say no. Motion carries.
Thank you. Last on my list, this is an update at the October meeting, and then in November, the board reviewed an application for a reinstatement of a barber school. Dr. Barbara Winfrey appeared before the board. That application was denied, so this is simply a quick update. The investigation is ongoing. So far, I personally have been able to speak to a few of the students. We have not gotten anything in response to the complaints open in writing yet, so you eventually that will live its course. The investigation will be presented as well. At this point, there are 2 individuals that I spoke to, Mr. Maldonado and Ms. Magali. One was stopped from testing altogether, and he was sent a letter, so Sherelle did a fantastic job drafting the letter so that they would make sense. And then Ms. Magali actually passed both exams, but we stopped her license and sent her the letter. Both students' stories were relatively similar. They went to a location. It was more of a barber shop as opposed to a school. On occasion, there was someone there that could teach them. Otherwise, they just sat and did hair. I was given an amount of what they paid in cash. It was a very sad story. They did not get physically irate with me, which is surprising because that's just a very difficult situation. They think they're finished and we've stopped it. I also pursued heavily the search for instructors that could have taught. The board saw at both meetings an instructor's name was put on the record. I've spoken to both of them, one in particular who owns a school, and he has nothing to do with the school, hasn't in forever. So it appears that school hasn't had an instructor, even though hours were turned in all the way through June, I think, if I'm remembering all this story, easily for a year, maybe longer. So that's kind of where we're at as the investigation will continue.
Okay, thank you.
And I put on the record an update from Sherelle for our rules, so I'll turn it over to you if you've got anything.
Hi. So I just wanted to update you all on the rules regarding the equipment requirements. Those are still being reviewed internally. They go through several individuals before we determine whether or not there have to be substantive changes. And so I wanted to let you all know those rules are still circulating. And when I have a more substantive update, I will definitely let you know. But I wanted you to know that those are moving along. Thanks.
Very much. Are we at the bottom of this list?
It is yours if you've got anything else. You're done.
I'd like to say Merry Christmas to everybody and safe holidays and all that stuff.
Do we have the dates for the meetings next year?
We do. They've been approved and they're on the website, but I will send everyone as soon as I get back that document. So you all
All of the
have
extra
it.
meetings I'm coming to?
Yes, I will send out the document with the 2019 dates.
Thank you.
You got it. Thank you.
All righty. In that case, do we have a motion to adjourn?
I make a motion to adjourn.
Second.
With a motion and a second to adjourn, all in favor say aye.
Aye.
Christmas.
Aye.
We're done.
Merry Christmas, everybody.
Merry Christmas. Thank you all. Happy holidays.
Happy holidays.
Enjoy.
You're here and a safe trip home.
Yeah. What's the meeting?
Well done.
Have a safe trip home too.
Shopping?
No, I have a piano student.
Christmas, everyone. Piano student?